House Resolution 495, the gentlewoman from Wyoming, Ms. Hageman, and a member opposed each will control 5 minutes. The chair recognizes the gentlewoman from Wyoming.
Thank you so much, Madam Chair. The Separation of Powers Restoration Act, or SOPRA, is great legislation which I fully support. My amendment is simple and seeks to clarify that de novo judicial review applies to agency guidance as well as to agency rules and congressional statutes. Specifically, my amendment explicitly states that interpretive rules, general statements of policy, and all other agency guidance are subject to de novo judicial review. Unlike rules, guidance is undefined in the APA's definition section. Agency guidance consists of interpretive rules that explain how agencies interpret the statutes and rules that they administer, and general statements of policy that prospectively advise how agencies may choose to exercise their authority. Guidance is not subject to the APA's notice and comment requirements, and, at least not officially, does not have the force of law, or at least shouldn't have the force of law. Yet we have seen a growing trend of the administrative agencies attempting to use guidance to have the force of law, while at the same time avoiding even the APA process. For example, in my private capacity before being elected to Congress, I was part of an effort to push back on the Department of Agriculture's attempt to mandate RFID ear tags on the cattle and bison of our nation's ranchers. The agency tried to force this on the agriculture community through a 2-page guidance document that was posted to the USDA website. This circumventing of the congressional, legislative, and agency rulemaking process would have cost our cattle producers $2 billion to comply with this guidance, all without a single comment or public hearing. Further concerning is that guidance is often not judicially reviewable because agencies then claim that it is not final agency action. And even when it is reviewed, the government then asks for deference to the agencies by the courts. While the language of SOPRA is implicit that the requirement for de novo judicial review of all relevant questions of law applies to agency guidance, my amendment would make it explicit. In closing, my amendment would clarify that agency guidance, which agencies routinely abuse, is subject to de novo judicial review under this bill. Thank you, and I yield back. I reserve.
Gentlewoman from Wyoming reserves. Does the gentleman from New York seek recognition?
Madam Speaker, I claim the time in opposition.
Gentleman is recognized.
Thank you, Madam Speaker. Madam Speaker, as agency heads have stated time and time again, guidance documents, general statements of policy, and other agency guidance do not have the force and effect of law, and the agencies do not take enforcement actions based on supervisory guidance. This amendment would unnecessarily require judicial review, de novo or otherwise, of guidance documents that have not been interpreted by courts to be given the force of law. Before I discuss how guidance documents and rules differ, let's take a minute to consider the pure breadth of materials this amendment would cover. Interagency statements, bulletins, policy statements, questions and answers, frequently asked questions, statements of policy, and advisories. Rules and guidance from agencies are not only given different weight in court, but they also are developed through entirely different processes. Rules are made under the Administrative Procedures Act and thus follow a structured process for soliciting public comments, the review of those comments, and the release of any final rule. Agency guidance documents, by contrast, are not made under the APA process. Guidance documents are not subject to public review and comment. When you consider the range of materials that falls under the category guidance, this naturally makes sense. A frequently asked questions page on an agency website cannot and should not be placed in the same category as rules that undergo months and years of review and development. Not only is it wrong as a matter of law to conflate these two classes of documents, but it would also signal to the judiciary that Congress sees them on equal footing, that is, rules and guidance on equal footing, which would muddy the judicial review of agency action. I imagine the amendment sponsor did not intend her amendment to accidentally expand what kinds of instructions from agencies should be given the force of law by expanding the Separation of Powers Restoration Act in this fashion. But in any case, that is what this amendment would do. And if agency guidance were treated the same as a rule, as wrong as that might be, agencies would be chilled and warned against providing much-needed information to the individuals and businesses who seek more feedback on an agency's point of view. They would be very hesitant to answer questions on question lines. Finally, as I noted in response to a similar amendment to the REINS Act yesterday, by requiring agency guidance documents to receive the same review as rules, this amendment would create confusion among businesses subject to oversight from our executive branch agencies as to how much weight they should give agency guidance. Expanding this bill also to require any guidance the agency gives to businesses about how the rules will be enforced is a drastic expansion of the Separation of Powers Restoration Act, and would ensure that agencies provide less guidance for businesses, thus creating more uncertainty for businesses. This amendment is an overstep that would further stifle the work of our agencies. I therefore oppose this amendment and urge my colleagues to do the same. And I reserve.
Reserves. Gentlelady from Wyoming is recognized.
Yes, thank you. The irony of what my colleague on the other side is saying is that the only time that the courts would be addressing guidance is when the agencies are attempting to enforce it against someone outside of the agency. So again, an example might be the EPA attempting to enforce their guidance against an irrigator in Wyoming because he moved an irrigation ditch. And they've concluded that such irrigation ditch, through their guidance, is actually a navigable water of the United States. Now, fortunately, recently, the Supreme Court of the United States slapped that down and has indicated that the EPA is no longer going to be able to abuse its power and try to control irrigation land and other resources by claiming that mud puddles and such are navigable waters of the United States. But that's just an example. The only time that the courts are going to be looking at guidance is if the agencies are attempting to enforce it. So while my colleague on the other side would argue that these are just frequently answered questions and internal documents, the fact is that this is the way that agencies are circumventing the APA, circumventing the law, and attempting to enforce unofficial documents against the citizens of the United States of America. I would also point out that yesterday we did pass a similar amendment to the REINS Act, and what this does is it makes SOPRIS and REINS consistent in terms of covering guidance documents as well as official rules. And with that, I reserve.
The gentlewoman reserves. The gentleman from New York is recognized.
Madam Speaker, judging from what the gentlelady just said, the gentlelady does not understand the process at all. Courts do not enforce guidance. So we're not prohibiting them here from doing what they do not do to start with. Courts do not enforce guidance. Guidance simply tells people how the courts will enforce the rules promulgated by the agencies. So to say that you can't have guidance is to say that people must act in ignorance and bet their businesses on what the agency will do without knowing it because the agency can't tell them. That's absurd. I reserve.
The gentleman reserves. Gentlewoman from Wyoming is again recognized.
I find it so ironic, having been a practicing attorney for 34 years and fighting over these exact battles in court, that I'm having someone who hasn't practiced for decades tell me that I'm ignorant. In fact, the agencies are the ones that attempt to enforce guidance, and I have defended lawsuits along that very line. So while someone who may have sat in this room for years believes that he has the ability to judge what people in the real world deal with, the fact is that agencies do attempt to enforce guidance against citizens of this country. The only thing that this amendment does is says when that happens, the courts are to apply de novo review to the interpretation of what that guidance means. Nothing more and nothing less. And with that, I'm ready to close.
The gentlewoman reserves. Gentleman from New York is recognized.
I'm prepared to close.
Gentleman reserves. Gentlewoman is again recognized to close.
Yes. Again, this is a very simple amendment that says to the extent that guidance documents are before the court for interpretation, the courts must apply de novo review rather than defer to the agency interpretation of that guidance. Very simple, something that's appropriate and ensures that we're following our constitutional separation of powers. With that, I yield back.
Gentlewoman Ills. Gentleman from New York is recognized.
The gentlelady is accurate as to what SOPR would do, and for all the reasons I stated before, it's a terrible bill, as terrible as Raines is. I'm not going to repeat those arguments. But as to this amendment, I don't have to practice law recently. I know how to read a bill. There are lawyers on my staff who know how to read a bill. And we know, as I said before, that courts don't enforce guidance. There's no such thing. Guidance issued by agencies tells the courts how to interpret the rules promulgated by those agencies. That's a simple fact. It's not debatable. So to have an amendment that says there shall be no guidance is to have an amendment that says businesses should operate in the dark and bet their businesses on what an agency might do. That is ridiculous and harmful to business. And I urge people to oppose this amendment as I urge them to oppose the bill, and I yield back the balance of my time.